at 9 a.m. Eastern. The words that shaped the nation. This is America and the Courts, C-SPAN's weekly look at the federal judiciary. In this edition, Associate Supreme Court Justice Stephen Breyer visits with students at the University of Kansas Law School in Lawrence, Kansas. He spends time talking to the students and taking their questions. Then, in about 45 minutes, a look at the Supreme Court justices featured on U.S. postage stamps. Now, here is Justice Breyer from the University of Kansas Law School.
It's very nice to be here, and Danelle and I are old friends, and it's really a treat to swear her in. And it's because we're old friends, she said I was really the architect of the guidelines, knowing that they're about as popular as cholera. Right, that's true. And I worked, in fact, Danelle, you may not know it, years ago when I worked on a Senate staff, I worked on airline deregulation. And when we were trying to explain the guidelines to the different circuits, the commission sent me out to talk to the different circuits, and I was at the 11th Circuit one evening where they were not delighted with the guidelines, but in making conversation, Judge Hill, who's very nice, began to ask me about my career. Now you have to know that was, I remember the date, it was October of 1987, because only 2 or 3 weeks earlier the stock market had crashed. You weren't even born then, I realize, but nonetheless, us older generation remember that. So Hill said, what did I do? I admitted I worked on airline deregulation, and he said, oh. He said, you worked on airline deregulation, did you? And now you've worked on these sentencing guidelines, have you? I said, yes. He said, they didn't just put you in charge of the stock market, he said. Anyway, let's save that. But I thought I would be happy to talk about the court and answer your questions. I explained, maybe should I spend about 5 minutes saying, I might spend about 5 or 10 minutes, which to describe what is it mechanically that I do. That is, what is my day like? They're not all as pleasant as today, but it's still very interesting. This is what I do. There are basically 2 jobs that the court has. I first have to decide what cases to hear, and then I have to decide the cases we do hear. The first job is complicated because there's so many applications. There are between 7,000 and 8,000 applications every year coming out of the circuits primarily, but also state Supreme Courts. We decide only questions of federal law. That's probably about 4 or 5% of all the law in the United States. I mean, as you know, most law is state law. We decide federal law. So of the 50,000 or so appeals in courts of appeals, and maybe an equivalent number roughly in state Supreme Courts that involve federal issues, 8,000 will come to us, 7 to 8. And now how do I get to the 150 or 100 or 80, which I think it is about that this term? Well, say 7,500, this is what happens. That's about 150 a week. And the law clerks in the court, of whom altogether there are about 30 to 35, will take the 150 each week, divide them, so that's about 5 per clerk. And the clerks will go through each one very carefully and write memos in which they explain the arguments, the issues. And we then get the memos. So that each week I have a pile about like this of about 150 memos. And the first thing I do each week is I go through and separate that big stack into a big stack and a small stack. And it's a very small stack, I don't know, 10 to 15, that I think are serious candidates for a hearing. Why so few? Well, it's important to remember that every person in that stack has already had a trial and an appeal, and sometimes 2 appeals. And it's equally important to remember that we are not there to correct errors in the lower courts. You could go on forever. You could have 10 sets of courts, one on top of the other. But we are there, as we see it, primarily to create a uniformity in federal law where the circumstances call for that. Now, when do they call for that? They call for it in all likelihood if the lower courts have come to different conclusions on the same issue of federal law. Suppose they've come to the same conclusion. Well, Justice Jackson said of our court that we are not last because we are infallible. We are infallible because we're last. That's a little hard. I always have trouble figuring out what that means, but I think it means we're not there because we're so brilliant. We're brilliant only in the sense that we are the last word. Someone has to be last. And so if the lower courts have come to only one conclusion, what need is there for us to step in? But if they've come to different conclusions, there is a need, the need for uniformity. And almost all the cases are like that. I say almost because sometimes we can see a need for deciding a case, even though there is not a split in the lower courts, and quite often there will be a split, but there will be some special reason stemming out of the case why we don't hear it. Maybe there's a jurisdictional problem, maybe it's a recent split, maybe it will cure itself, a lot of reasons we might not. But you first should say, if you're interested in the Supreme Court and what we're hearing, if there is a split, the question is, why didn't they hear it? And if there is not a split, the question is, why did they hear it? Now, there are often answers to those questions, but that's the basic question. So now you see why I can take this stack and I can reduce it to about this size pretty quickly. Now, at that point, I will give my own law clerks the ones I think are candidates. And they'll look into those, and then on Wednesday afternoon, I will meet with my clerks, all of them in the room, and we'll go through each of those cases that I've pulled out. And the papers are there on the wall, right in the bookcase by the wall, and I just pull out what I want. I can take it home, read it, whatever I want. But by the end of the afternoon Wednesday, usually a conference, maybe not too long, because all I'm deciding is, do I want to have this case discussed? If I want to have it discussed on Friday, I put it on the list for discussion. Any one of us can put a case on for discussion. We usually do it in order of seniority. So I'm last. That means if someone else hasn't put it on, I think my chances of getting it granted may be small. But I put it on because sometimes it's granted. But in any case, we that way work out what will be heard Friday. On Thursday, the list of cases that will be discussed comes around. I discuss them all with my law clerks again. This time I'm trying to work out how to vote. I read what I want to read or feel is relevant, or I work out my own votes. And then at conference on Friday, the last thing we discuss are the certs. And when we discuss the certs, we're all in a room a little smaller than this, and there's a table in it, oval, and no one else is in the room but us. And the chief always begins the conversation. He'll say the case of such and such is on the list. Here we are. Now, I vote to deny because of such and such, usually very brief. And then it goes to Stevens, and then O'Connor and Scalia, Kennedy, Souter, Thomas, Ginsburg, and me. I'm over here, a junior. I'm next to the door, and my job, as I say, as the junior, is I open the door. That's what and I'm now the most senior junior justice they've ever had. I've been there for a few years, and so I've gotten very good at opening the door in case somebody knocks, and I feel my colleagues feel in that area my work is satisfactory, and that's the discussion briefly, you see, on a cert. 4 votes is a grant. And if any one of us, listening to the others, begins to think, I'm not sure, any of us can pull the case off and hear it again next week. In the meantime, we'll look into it more deeply, write a memo to the conference. And I think it works reasonably well. All right, so that's probably 20% of the job. maybe a little more. Now, how do we just deal with the cases we grant? Well, once they're granted, then the lawyer is set to work and write briefs. And we read the briefs and hear the oral argument in batches, 7 batches over the course of the year, 2 weeks each time of oral argument, October, November, December, January, February, March, and April. Now, before those oral arguments, right now you see I'm in a session between 2 sets of oral arguments. And before I hear the oral argument, I will have read, for the February session, there are going to be 2 weeks, 3 days of oral argument each week, 2 cases each day, let's say 12 cases. In fact, there are 10 in February because there's a holiday, but 12, let's say. And I'll read the 12 sets of briefs. They're usually, some are this much and some are like that. There's always a petitioner in blue, respondent, red, solicitor general, gray. I don't know, the government is always gray. Amicus, for the petitioner's side, light green. Respondent side, dark green. It's all color-coded to help us. And I read them all. And in addition, I give the sets to my law clerks. I say, you each have 3 sets, I have 12, so you better know it 4 times better than I do. And before, I get about a week before the oral argument in February, I will have spoken to my clerks, and I will have said what I would like them to write a memo on. And I want, these 3 questions, I want to find out this, this, and this, and anything else you want to put in the memo, fine, but please be sure to answer my questions. And I'll get back a memo from them. I'll read it. I'll discuss it with them. And then I'm ready for oral argument. So you see, I've read the briefs, I have a memo, and I've had 2 discussions. And at that point, every one of us has some, I don't know that everyone's system is the same as mine, but everyone has some such system. So when we walk into oral argument, when I walk in there on Monday morning in February, I will I feel reasonably well prepared, and so will my colleagues, and therefore the purpose of this oral argument is not for the lawyers to tell me about their case. I feel I know it. And if there's a new argument, why didn't they make it in the briefs? That's where it was supposed to be. So we see that the purpose of the oral argument primarily is to answer questions that the judges may have growing out of the briefs. And that's what we do. And it's still very difficult for the lawyers. I mean, I'll go into that if you have questions about it. But it's a hard thing to argue a case in our court. We then hear the oral argument, and then let's say that's Monday, Tuesday, Wednesday. On Friday, we're in conference. At the Friday conference, we go around the table for the discussed cases exactly the same way that we did with the certs. And everyone presents his or her view and gives an indication of how he or she is likely to vote. It's not definite, but it's getting more definite all the time. And by the end of the conference, it's probably fairly clear how the court is going to break down in this case. And at that point, Monday, after the oral argument session, the chief, where he's in the majority, or the senior justice who's in the majority, will assign cases for writing. They're assigned, and I then begin to write. I'll get my law clerks to prepare a lengthy memo or a draft. I take that, I read the briefs, I read what they've written, and then I go write a draft. And then they take my draft and say it's not all that satisfactory in their opinion, and then they will rewrite it. Fine, wonderful. Then I take what they have, and I go back and I rewrite it. And eventually, I'm satisfied, and I think they are, and we have a final product that's pretty solid, and it circulates. And at that point, all the members of the court will begin to think about this. They'll either join me, or they'll write a dissent, or they'll write their own opinion. And those circulate. And sometimes people change as a result of what's circulating. They can make suggestions for change in each other's opinions. It's a little bit just like a court of appeals in that respect. And then eventually, at the conference, first thing always, the chief says, here are the circulating cases. Has everyone written anything they have to write? Yes. Has everybody joined one or the other of these? Yes. And that's it. When that happens, down it comes. Next argument day, next week. And that's it. That's the process. You see, I can describe it in about 10 minutes. Why? Because I like to say that the judiciary, the judicial branch, by and large, I'm not going to say 100%, But by and large, the work of the judicial branch does get carried on in the way that the 12th grade high school civics text describes. They say, well, what really goes on secretly? Not much. What goes on secretly when you're writing your first draft of your paper? I mean, do you think everyone wants to see it? Your mother might. But I don't know. I mean, we're sitting there working. I said, what is it primarily? What I told my son when he'd complain about homework, I'd said, well, if you do your homework really well, then you'll get a job where you could do homework the whole rest of your life. I mean, that's, but it's very interesting. You see, the interest is in the content. And it's difficult and interesting, and we all know quite significant. But anyway, see, if you're in Congress, think to yourselves as law students, when you read a statute, if it's a good statute, does it tell you in the statute why the senator voted for the statute? Of course not. What you get out of a statute is you get the ultimate product in terms of what the law is. It doesn't explain why it's the law. So obviously there's going to be an interesting story as to how those words got where they are. Now think of a court. Again, I won't say 100%, but quite a lot. An opinion, when it's a good opinion, explains why it's come to the result that they've come to. And where it's a good opinion and the process is working well, there aren't some other reasons. The reasons that are there are the reasons that the judge had. And the more honest in writing down your reasons, what they really are, and that's, I'd say, is a virtue of the conference. Conference people are to say what is their actual reason for deciding this, that, or the other thing. And as a judge, what you want is an opinion. That's the goal. An opinion that will clearly explain and reflect what your actual reasons are for reaching the result that's there. Now, I'm not saying there's never an inside story. I'm not saying there is never something that everybody'd love to know if only they could. I wouldn't say never. But I'd say comparative institutions, comparing the institutions, pretty much what you see is what you get in the judicial branch. All right, now I'll stop there, and you can ask me whatever you want. It's my problem whether I answer. And you are gluttons for punishment, at least some of you, because you were at the Cherokee lecture that I gave only an hour or so ago, and some of you are back. So I'm very glad to see you. It's very nice to be here. Anybody have any? Yes. Good.
Well, I personally have very great opinion about you. Yes. But I still have to ask this question.
That's fine.
This is regarding Paula Jones' lawsuit.
Yes.
And there have been many opinions. And Vincent Vigliosi says that the following, quote, Supreme Court ruling is so shallow that anyone using even an ounce of common sense could navigate its weak currents, and calls it an incomprehensible and terribly flawed decision against the nation's most powerful and important citizen, and one that has injurious ramifications for all of us. It was a unanimous decision, if I get it right. What do you have to say about it?
Well, I'm tempted to say I wrote an opinion in that case, and it did explain very much what I thought. I would say this in terms of the criticisms. There's one, it all starts, that's what you're paid for as a judge. That's why they give you life tenure. That's why they even claim your salary won't be reduced. You're paid to realize everyone has his right to an opinion. And the virtue of being a judge is you have the opportunity to think it through, which is an opportunity not everyone has. To think it through, and then to write it down, and to recognize that what you say will have an impact. Remember, one of the greatest critics of the court was Roscoe Pound, who was a great law dean and put together all of modern jurisprudence. And he was once heard to remark, that judge is so stupid, he doesn't know whether he's a member of the historico-analytic or the empirical-sociological school of jurisprudence. Well, I guess the judge put up with that. And therefore, you see, when I hear the criticisms, I say, indeed, they may be right. I'm doing my best. I don't know. The way that you have to write these opinions is you get the arguments, you think them through, and you do your best. And two virtues in our court, which I told some of the students I talked to before, and I recommend it not just for judges, but for anyone. Rule at the conference. Nobody speaks twice until everyone has spoken once. Very good rule for small groups when you're trying to reach a decision. I'd say a particularly good rule for the person who's the most junior, namely me. Second rule, and this is more in response to what you say. Each case is a new day. Of course it's true that many of the things that we write are controversial. Maybe fewer than you might think, but many are controversial. And of course people will have strong opinions on both sides of these issues, and they will express them. And I wouldn't say I would retreat to saying, oh, we must be right. I know that sometimes things I do are wrong. And so you can read criticisms and learn from them, but it's always with an eye towards what's going to happen next. Each day is new. Each case is new. We can learn from the past, but we go on to the future. So that is not the first strong criticism, I am sure, and certainly won't be the last. All right. Yes?
With that question in mind, with the November presidential election, but right after you granted cert and before the final ruling of all of the Bush versus Gore cases, a lot of the media and a lot of legal scholars wanted to draw lines as to which justice would go which way. A lot of them would go with states' rights versus federalism justices, and the final result seemed to turn the other way. With a partisanship edge in the air, could you address that as the perception of that leaking into the judicial system?
I'll tell you what I think about that. I'll tell you what I wrote, and maybe that will help. Because normally, when I speak to students in groups quite a lot, and I normally try to say to them when things arise, when cases come up that have a political charge. I'll give you a little perspective. Say about 40% of our cases are unanimous. Maybe another 40% or so are 1 or 2 dissents. 20% or so are maybe 5-4, sometimes 6-3, very contentious, and sometimes have a lot of impact in the country. And those are the ones you read about. So for an ordinary reader, they think you see a higher percentage of what we do is tremendously controversial, a higher percentage than really is. But what about those cases? What I'd like to explain to students is the following. Why is it that 5 tend to think one and 4 the other? And if you look at it, sometimes it's mixed up, but it's not always. The majorities do shift, but you can also find patterns, and many of the law professors and others look for patterns. And they find them. I say, well, that's not entirely surprising. And I want you to hold your reaction for a minute, because you're first going to disagree with what I say in light of the case you're talking about, but don't jump too quickly. All right? What I usually say is this. Look, there is no answer to some of these good cases that comes right out of pre-existing black-letter law or some other theory of law. There is no answer written in stone somewhere that you can go and read off and then know what it's going to be. After the event, sometimes people go back, but it doesn't feel that way at the time. So you have to think them through very carefully, which we do with all, but a lot of them, you look at the Constitution, what's the meaning of the word liberty? In the 14th Amendment, it doesn't actually specify in great detail. You look back to precedent, and sometimes it's a little hard to find a precedent right on point. And if it was right on point, what's that case doing in the Supreme Court anyway? So these are open often. That doesn't mean arbitrary. It means people decide not on the basis of personal preference. I say, you think we decide on the... It never feels like that. I say, well, what then is it? Is it just your ideology? I say, well, it's not quite ideology. I mean, when you're looking to these things in the meaning of the Constitution, you look to words, you look to traditions, you look to cases, you look to purposes of these provisions, and you look to the impact in the world. That's past, present, and future. And I think all those things are fed into the mix. And now different judges, depending on their own life experience perhaps, or how they see the law, may tend over a course of time to put together these different aspects of a difficult constitutional case in different ways, some tending to weight more heavily language, some tending to weight a little more heavily impact in the world, so, some being a little bit more flexible with the use of tradition, some being determined to look more into history, you see. But it's a question of tendencies and it's a question of mix, and it's not surprising on cases that tend to group themselves similarly in respect to what parts of the mix will determine the outcome, that the same judges tend to decide those cases similarly. That's what I call judicial philosophy, or judicial background, or your own life experience. That isn't exactly ideology, though you could shade into ideology, and it isn't politics. I'd say those are the explanations. Now, the reason I perfectly well know that you're asking the question that you asked is because, well, wasn't that a case of politics? That's what you're actually saying. Wasn't that? And I'll tell you what I did say, in my opinion. I'm certainly not going beyond my opinion. But I'll tell you what I did say. And I said it deliberately, as we all do when we write opinions. What I said was, I gave an example. The example that I gave was the Hayes-Tilden election of 1876, which those of you who have been either reading the newspaper or are historians are by now quite familiar with, perhaps much more familiar with it than when we were at school. But in that election, very much like this one, Hayes, I think, won the Electoral College by a vote, and Tilden had more popular votes. And there were contested delegations to the Electoral College from Florida, among others. And Congress appointed a committee to resolve those contested fights. This is all in the opinion. And I'm putting it there for a reason, for several reasons, but this is one of them. And on the committee that they set up, knowing it would determine the outcome, there were 5, 5, and 5. Who were the middle 5? The middle 5 were 5 Supreme Court justices. And those Supreme Court justices, of the 5, one, Bradley, had a reputation for being absolutely above board. I mean, you know, very careful judge, good judge. He's not going to be influenced by politics. That's what people thought. And at the end, he who had been appointed by a Republican voted for the Republican candidate, and who won 8-7 on the commission, thereby got the election and became president. All right. Bickel, Alexander Bickel, who's an historian, looked into this and wrote, among other things, wrote on this incident. And he said he was convinced, having done the history of it, that political considerations did not influence Bradley. That, in fact, he was worried about the extent to which you'd look underneath the certification by the official in Florida of who was actually the winner. And this was what was moving him, a rather legalistic point, and not a point about politics. And Bickel, who is certainly a fine law professor, good history, wrote that, but that's what I put in the opinion. Because I wanted to put that in, to say that, and then to say nobody at the time believed it. You see? All right. Enough said. They're phoning to say what an unsatisfactory answer that was. But that's what I put it in, and that's what I think the circumstance was. And, yeah.
Well, on that, and it kind of, I thought of this when you were discussing earlier about how you disagree, but then it's a new day, and everybody moves on. But it seemed like Stephen's dissent was just so scathing, and talking about the loser being the people's impression of a judge as a impartial arbiter of law or something like that. It seemed like there were some really heated discussions going on, and the whole timing of the release of the opinion and everything. I mean, was it pretty difficult the next time you all got together to? Was it pretty tense? Or,
We've been through, but one thing that I said, a number of things. One is that by now I've been there for, even before, on the circuits we have some difficult cases where feelings may run strong. And I've certainly been through a number of cases in the Supreme Court where people have strong feelings on opposite sides of issues. And despite what can be very strong feelings, and it is true as of this moment, that I cannot remember an instance, any instance, in the conference where we sit, where a voice has been raised in anger. And I cannot think of any instance, including every one that's now coming to your mind, any instance in which anyone at the conference has made a remark about some other member of the court that was either slighting or some kind of hidden insult or direct insult or anything. There's nothing like that. It's very professional, and people get on very well. And in their professional relationships, in their personal relationships on the court, they're fine. They're cordial, they're friendly. And I think that was true, and it is true as of this moment. And I expect that that will continue. Yes?
One interesting feature of the recent election cases was the ability to have, with the click of a mouse, an audio replay of the court's oral argument. And of course, there was talk about whether this was an occasion for televising oral argument. And I'm curious about your thoughts about the immediacy of access to oral argument, audio, and television as well.
Well, I think that the way in which it was done, you're better judges of this. I mean, I listen a lot to what people, I'm very interested in what people think of the way in which that was done in the case. Yes, that's what my impression is, that people have found it helpful, and I think from the court's point of view, I've gotten back very positive feedback. That is, that people begin to understand, which they do at some level, and you understand better than others because you're law students. I mean, we are listening in a court of law to arguments as to very difficult cases, and these require thought, and they require preparation, and the question, people are professionals, and going back to your previous question, what good would it possibly do for a group of judges inside a conference, or a group of lawyers when you're practicing and you're dealing with people on the other side? What good would it possibly do to become emotional or excited or say, but I think this is very important? The person who disagrees with you would simply say, well, I think this is very important, because they do. And so we've learned that we carry on this kind of disagreement in a very civil way. Now, for the public to see the way in which, even in this very contentious matter, a matter that's divided the entire public of the United States, for them to understand that when you start to talk about law, when you start to talk about lawyers, when you start to talk about judges and courts, what you're talking about is people who carry on a discourse seriously, informed, and completely with civility. Now, I think that's a very good thing for all of us in the room. And the way in which that was conducted, I think, was good. What will happen to television is something of a different story, I have to say. I don't know. You know, some of my colleagues are very much opposed. The arguments there are very complicated. And they're different. They're somewhat different. They are if you... we have to worry about what would happen at and you want me to go into that too? I'll tell you, everyone understands the arguments for it, First Amendment relationship and so forth, which I'm sure everybody in this room is fully aware of. It's harder for people to understand the arguments against it. But some of the things that, that people worry about in the court is that if we were to introduce television, would suddenly there become an unstoppable pressure to have it in every court in the United States? And were that to happen in a criminal proceeding, as it does in some instances, I'm not certain of the impact there. Because you have witnesses, you have jurors, you have, well, some states are trying it and others are not. And so we'll know eventually, maybe, if the research is done with care. And another thing people worry about is, no, they worry about that. You see, you understand that this is, the oral proceeding is not the whole proceeding. I've just been describing that to you. you understand how in a court of law, you're talking about principles that have a reach and an importance beyond the immediate case. Is it possible to communicate that when what is being communicated in the Supreme Court is simply that 1 hour of oral argument? What will people learn? What will they think is actually happening? Will they understand that something's happening other than the story, the human story, of this plaintiff and this defendant? When people hear law in a sense, and this is, I'm sorry you're going into law as I'm sorry for myself in this sense, most people respond to other people as human beings. We have to keep in mind that the principles for which we are arguing are going to have broader application than that one person in front of us. So people see this story, that story, and the other story, but we're working in an institution that has these principles that extend to a lot of people who aren't in the room. All right, so all of that, I mean, I'm giving you an idea of some of the complexity of it and why people in the Supreme Court are somewhat concerned about it. Why are there reasons for not doing it? But the upshot is that I think everyone was satisfied, or was satisfied with authorizing what happened in that case, and I think it worked pretty well. Yes?
Justice Breyer, I'd like to thank you for sharing your interpretation of the Cherokee versus Georgia case. And I'd like to ask you, in your opinion, how do you see sovereignty for Indian nations in the future? I mean, because it kind of tends to go back and forth between what do you think the future of Indian nations remaining sovereign?
That is, I'm not a great expert on the Indian nation law, and that seems very much a matter which is I think the nations, the Indian, I think they work that out primarily in Congress. And Congress has shifted over time, and the problems have shifted over time. And I'm sure they're different today than they were 100, 150 years ago. We do get quite a lot of cases. When we get the cases, they're mostly questions of interpreting the federal statutes. Quite a few of them are, and they're usually quite difficult. They're well argued and difficult. So I don't have an informed view because it's not going to be, I don't think it'll be our court that really decides that. Yes?
Brian, too, I'm glad that you're here, and I guess I want to bring in our students a little bit on this, because 12 years ago I was in your administrative law class, and I don't ever recall asking a question, and I'm thankful that I have the kids now. Students should always ask their professors questions, because you never know when they're going to be famous, so you should be prepared for that. But sort of tying into Lisa's question about the Indian law cases, but really as it relates to history. When you talked about the Cherokee Nation versus Georgia case, that was a case that really tied into a historical principle, one that really eliminated, in many ways, the autonomy, the sovereignty of Indian nations to become domestic dependents of the United States. And I'm just sort of wondering, in the course of dealing with these issues in a contemporary sense, how do you build in that history, that you talked about earlier, and looking at this as, I would look at it as an action of a colonial government, sort of wiping out the recognition of another people. And yet we know, and you know, of course, that contemporary cases tie back into those ancient precedents. They're very alive in this particular area of law. Is it just simply a matter of you have the narrow statutes and the narrow cases, or how can you really internalize 150, 200 years of legal, political, social history of another people when you're deciding these cases? How can you reconcile those two sort of tensions, I guess?
That's a very good question. What is the relevance and the use of the history? I can tell you why I wanted to spend the time on this case, which grew out of a course when I was teaching called The Development of Legal Institutions. You didn't take that? Well, I think that was perhaps, no. That might have been quite lucky for you, actually, because we taught, Charlie Nesson and I taught that for a while. And we were trying to find instances, which this case illustrates so beautifully, of the institutional history and its relationship to how people in the country feel. And I think that's a case that well shows the difficulty of the court achieving an objective where the country is simply not in a mood to accept it. Now, what does that tell us? Well, we know our court It tells us a lot less, I think, for a judge of a lower court, actually, who is somewhat more bound because the questions that come up are usually not as open. But it does tell us, I think, quite a lot in respect to, it tells us something in our court. And one of the things I get out of it, which is not directly part of my job, but indirectly is part, it makes you understand how much what we do is dependent upon people who are not judges and who are not lawyers understanding what we're about and how it affects them. So if I'm talking to people, judges from other countries, I get that all the time now, you know, the judges in France and judges in Latin America and judges in the Eastern Bloc, and Danelle went to Albania, and I've noticed it's improved quite a lot, the judicial system. But they want to know, what's the magic? What are the words you put on the paper to do this? And of course, what I reply is no magic. There is no magic. We fought a civil war in this country in order to make real the principles that had begun in the Declaration of Independence and were there in the Constitution. I'm sure that it wasn't the words that brought about the eventual result, but they were necessary, but not sufficient. And so what they have to learn from that, and what I guess here people can't forget, but how often they tend to forget it, is the need for lawyers in particular, members of the bar, to explain, to be sometimes maybe in a high school class on law days. That's sort of a kind of exhortation, or I don't want to sound too much as if I'm preaching, but my goodness, how you see the need for that. The need to understand how the case fits into a context is the need to understand how others have to understand what we're doing. And that's what that shows to me. And that's exactly why I saw that at the time, but I see it doubly or triply now.
Glad you did, because it was like Act 104, and I think you've done more for Indian law in one day than...
But it's fascinating. See, the court decided, they didn't want to decide it. And you can understand why they didn't want to. They didn't want to decide it because they're afraid they're going to weaken the institution. You know, and say, what good will we do? We'll weaken our own institution, and it won't do the Cherokees one bit of good. And then they begin to think, well, but look at the principles here. We can't. There's no way. And Story says, but we must decide this. They're right. And eventually the court says, all right, you're right, you're right. We'll do our job, let the others do theirs. And the others didn't do theirs. And you see, there we are. So how do we, yeah, all right, yeah.
Mark, can I just ask you one last question? We're about out of time. But curious your thoughts on law clerks in a couple of respects. One, they were very visible throughout the Bush versus Gore litigation on TV. And I'm curious if you have...
Former law clerks.
Former law clerks, yes, not the current ones. And sort of how you feel about that. And then sort of also related, you say the case is over, we move forward. Is that the same for law clerks in your impression as it is for justices?
Oh, the law clerks aren't necessarily all working together in one institution for the next few years. So but the relationship of the law clerk, my law clerks whom I love, are like my family. And I think that every judge's law clerks feel that way, we hope. And the judges certainly do. And the relationship within your family is one of loyalty, and in the court, it is one of silence. And that means that what they see and hear and talk about is confidential. And that's, of course, because each of us, the judges, wants to feel free to say anything, no matter how odd it may sound, to see how they react, for example, or to discuss it. Law professors know that, and even law students. It's fun to say something outrageous. It's not fun if what you say as outrageous ends up in the newspaper. And the law clerk is in that confidential relationship, which is absolutely necessary. Now, law clerks often become law professors, and sometimes deans. Does that... Does that mean that they're forbidden forever from discussing a case? Of course not. They can go and discuss any case they want, exactly the same way as any other dean, any other law professor, any other law student, any other human being in the United States. The only thing that they can't talk about is what took place in the individual relationship at the court, in the relationship of law clerk at that year. That doesn't prevent them from criticizing and talking about cases that come down the pike. And so that's basically my view. A confidential relation is confidential. A confidential relation doesn't prevent you from acting like anybody else in respect to some case, particularly we have no confidential relationship about that case.
Justice Breyer is very generous with his time. I have to tell you that I asked him to come for the ceremony tomorrow, and between the dean and me, we stretched it into at least 2.5 days. And so we greatly appreciate your generosity. We also have a lot of other activities for him, so we thank you for your time.
Oh, it's nice for me. Thank you.